Sussex fans are claiming that Prince Harry won big in his court case against the Mirror, but if you ask me, 15 out of 33 does not represent a big win for Harry. Plus, even if he did win in the courtroom, he's still married to Meghan Markle, which makes him the biggest loser ever.
Hello, everyone. Welcome back to the King YouTube channel.
Honestly, I am baffled right now by all the headlines that are claiming that Prince Harry won in his case against the Mirror Group newspapers. I mean, last time I checked, if you only win 45% of what you're asking for, that does not represent a big win. A partial victory, okay, we could call it that. But we've got headlines like Prince Harry triumphs in phone hacking lawsuit, a great day for truth as Harry wins case. So in this video, I want to take a look at the sample of 33 cases that were considered in the trial, and let's look at which ones he won and which ones he lost. And then you can decide for yourself, is it a win for Harry, is it a loss, or a partial victory? Spoiler alert, he lost more than he won. As reported by The Times, Harry is alleging that 148 stories published by Mirror Group newspapers in its titles The Daily and Sunday Mirror and The Sunday People from between the years of 1996 and 2010 were obtained through unlawful means like phone hacking. Now, the issue here is that Harry needs to prove that they got this information from unlawful phone hacking. They couldn't have gotten it from any other source. In this trial, though, they only considered 33 samples, and 15 were found to be the result of unlawful information gathering, which means the other 18 were considered to be 100% lawful. In my opinion, this is not a big win. But anyway, let's take a look at which ones were considered unlawful and which ones were considered to be okay. Alright, so the first story was titled Diana So Sad on Harry's Big Day. It was published in the Daily Mirror the day after Harry's birthday, September 16th of 1996, the day after he turned 12 years old. And Harry's claiming that they hacked his phone to find out this information. But unfortunately, Harry lost this one because he didn't even have a mobile phone at that point in time. So it's impossible that they could have hacked his cell phone because, well, he didn't even have one. This is a perfect example, though, of the problem with Harry's cases. He can't even remember what happened. He just makes this stuff up, and then he expects the other side to have to produce the evidence. This one, though, was an easy one for the judge to decide because, again, Harry didn't even own a cell phone back then. The next story was published in the Daily Mirror on July 17th of 2000 with the headline, Princes Take to the Hills for a Gala. So according to this piece, Harry and William were going to go rock climbing instead of attending a gala for the late Queen Mother. And Harry said that he thought the details came from phone hacking. But the publisher is claiming the information, in fact, came from previous reports in the public domain, including an article in the Daily Mail a couple of days before, and also information they got from a St. James's Palace spokesperson. Well, the judge ruled, unsurprisingly, that this was not a case of unlawful information gathering. In fact, everything was on the up and up, so Harry again lost this one. The next one also made me laugh. So this article was published in the Daily Mirror on September 19th of 2000. The headline is 3 a.m. Harry's time at the bar. So essentially, Harry and his friends went to visit a gastropub in Chelsea for his 16th birthday. They went to a public place, and somehow Harry expected to have total privacy. He said he didn't know how anybody would have possibly known about those plans. He said, quote, he always found these kind of coincidences to be odd. But MGN is saying that in fact an agency had been tipped off that Harry was in the restaurant. Mirror journalists even spoke with the owner without any unlawful activity. So again, the judge ruled, no, this is not a case of unlawful information gathering. I mean, when you go out in public, you have no expectation of privacy. The judge was, quote, doubtful that Duke could establish a reasonable expectation of privacy. Well, of course not. When you go out partying as a 16-year-old prince in a gastropub in Chelsea, people are going to notice that you're there, Harry. The fourth piece was published in the Daily Mirror on November 11th of 2000 with the headline, Snap, Harry breaks thumb like William, exclusive. So according to this piece, Harry had chipped a bone in his thumb, and he had to undergo a minor operation after an accident that he experienced during a game of football. And Harry is claiming that he found the level of detail in that story surprising, and he suspected the palace had been approached for comment instead of being a source. But MGN is maintaining that the information was already in the public domain and had been repeatedly reported the day before that. Well, it sounds like MGN knew what they were talking about in this case because the judge said that Harry's claim was hopeless because the content was already released by St. James's Palace in a media briefing. Why does Harry even bother with these cases that he's clearly going to lose? What gets me about all of this is that Harry is the one who has already admitted that his memory is not all that reliable, that it just does what it does, and it may or may not match so-called objective reality, as he calls it. So why does he think it's appropriate to file a lawsuit against MGN when he doesn't have any real evidence? All he has is his pretty faulty memory to rely on. But anyway, let's move on to the next case. So the next case was published in the Sunday Mirror on November 11th of 2001. Headline: Rugger Off Harry. This article detailed an injury that Harry had suffered while he was playing polo. The result of this injury was that he had to stop playing rugby. And Harry has said that the article is brazen, and he attributes some details to a mysterious, unnamed royal source, in spite of the fact that there wasn't any comment from the palace. But MGN is maintaining that the information in fact came from a confidential Eton source. There is no evidence whatsoever of unlawful information gathering, but again, Harry believes it's the other side's responsibility to prove that they didn't gather the information unlawfully. Harry, that is not the way lawsuits work. Well, it shouldn't shock anybody that the judge decided this was also a loss for Harry. The judge said, news about rugby injury is the sort of information that a 17-year-old keen sportsman would be likely to share with his schoolmates. Of course, everybody at Eton knew about that. I mean, come on. Items 6 and 7 deal with the same issue. So the first article was run in the Sunday Mirror back in January of 2002. The headline was Harry Took Drugs and Cool It Harry. And there was another one in the Mirror on January 14th of 2002 with Harry's cocaine, ecstasy, and GHB parties. So in the first article, it contained allegations that Harry had smoked marijuana. And Harry claimed that while it was a follow-up story to articles in the News of the World, there were invoices regarding his friend Guy Pelly and people connected to the story at the time. MGN, of course, denied any unlawful information gathering. Instead, they claimed that news agencies, a freelance journalist, and a source were paid for the articles. And then the other article was a front page story, actually, alleging that some of Harry's friends had taken hard drugs right in front of him, including ecstasy, cocaine, and GHB. And it also reported that Harry's father, the then Prince of Wales, was terrified. So Harry claimed in his evidence, it is not clear to me where the defendant's journalist could have possibly obtained these quotes from. MGN, of course, maintains, though, that they didn't engage in any unlawful activity, and they also claim there is no evidence of phone hacking. The judge actually ruled in Harry's favor on these two incidents. The judge said that voicemail interception of the Duke's associates probably took place, though not of the Duke himself. So even though this one is certainly a win for Harry, I would still argue that it's not 100% a win in his favor, because even the judge acknowledges that Harry's phone was probably not hacked, it was probably a friend's. The next article came from the Daily Mirror on March 29th of 2002. The headline, Harry's sick with kissing disease. It was detailing Harry's diagnosis of mononucleosis or glandular fever and claimed that he was being made fun of by his friends and his brother. So Harry has alleged that he doesn't know how anybody outside the family knew this, and he believes the palace responded to information that was put to them. But MGN is claiming that the information was discreetly released by the palace to avoid extra attention on the royals while they were on vacation. The judge decided to rule against Harry in this one, and he lost. The judge said, quote, seems likely that it was St. James's Palace spokeswoman who first put the information into the public domain. So no, there was no phone hacking involved in this one. Next article was No Eaten Trifles for Harry 18, published in the Daily Mirror on September 16th of 2002. The article detailed how Harry spent his 18th birthday, including lunch with his family. MGN is saying they got the information from an interview with the Press Association for Harry's 18th birthday, but Harry's claiming that he was obliged to give the interview, and he described it as an ideal occasion for anyone listening into my messages to continue to do so. Well, that claim didn't make a whole lot of sense, so naturally, the judge did not rule in Harry's favor. He lost on that one. The next piece was run in The People on April 20th, 2003. It was describing how Harry was asked to be the godfather to the nephew of his former nanny, Tiggy Leg Bork. Matured Harry is a godfather was the headline. So Harry's claiming he has no idea where quotes from a royal insider about Charles's opinions on the matter came from. And he's claiming that MGN must have hacked his former nanny's or his partner's phone. But no, MGN has said the piece was a rewrite of a Sunday Telegraph column sold by a freelance journalist, and guess what? The judge agreed with MGN. He said, obvious from the phraseology, that the Daily Telegraph's Mandrake column was in fact the source. The next one also made me chuckle because it's absolutely ridiculous for Harry to claim that it was a result of unlawful information gathering. So the title is Harry to Lead Cadets March. It was published in the Daily Mirror on April 29th of 2003. The article goes into detail about Harry being given the role of parade commander at the Combined Cadet Force Tattoo at Eton. And Harry is claiming that the article's author is known to have commissioned private investigators, and he says that at least one of the articles is an admitted example of unlawful information gathering. But MGN is saying no, the information was already released by St. James's Palace, and that's where they got it from. Well, the judge ruled against Harry on this one too. The judge even said that Harry accepted the article was no more than a composite version of the Palace announcement and the Press Association report. Honestly, does he realize how stupid he comes across claiming that they hacked his phone and then they remind him that that information was already in the public domain and his response is basically, oh yeah. We're already up to number 12 with only a few wins. So the next one is Harry is ready to quit Oz. It was published in the Daily Mirror on September 27th of 2003. It's a page 7 story reporting that Harry was considering leaving his gap year in Australia because of the press. Harry is claiming that evidence shows that MGN was paying to have him watched. The piece describes that he was inside watching videos, and the publisher claims the information came from press statements by Clarence House, and it also showed up in other outlets as well. Again, poor Harry lost this one. The judge ruled that Harry's claim is hopeless because the source was the palace briefing Harry's own companion in Australia. Oh, Harry, maybe if your memory were a little more reliable, you wouldn't make yourself look like such a fool. And the next one is also completely ludicrous because Harry just visited a public beach. I mean, come on. This was a story with the headline Beach Bum Harry. It was published in the Daily Mirror on December 16th of 2003, and it was all about a visit by Harry to an Australian beach. Not all that interesting. I see he frolics and surf with bikini girls. Oh, how scandalous. So Harry is claiming that even though the beach was public, it wasn't busy, and he just doesn't understand how anybody could have possibly known that he was there. But MGN is saying that, in fact, the details were provided by an Australian freelance photographer, and also these photos had already been published in the Evening Standard. Well, unsurprisingly, the judge agrees with MGN on this one, and Harry lost. Now, this one I also find to be hilarious, because it's not like there are that many people in this world who look like Harry. It's funny how he believes that when he's out in public, he should still expect total privacy. Harry, no. Of course, when you're out and about in public making a spectacle out of yourself, people are going to notice you and you're going to get your name in the headlines again. Next item was published in The People on December 28th of 2003. The headline is Wills. Seeing Buell is the only way to stop him selling more Diana secrets. Harry, no. Buell's a two-faced beep who'll use visit to make money. This was a double-page article reporting on a disagreement between Harry and William about whether or not they should meet with the former royal butler Paul Buell over his ongoing exposes about Diana. So Harry actually ended up winning this one, even though it's really William who should have won, because I don't think it was Harry's phone again that was hacked, it was William's. The judge decided the information was obtained by hacking of messages between the Duke and his brother or other associates. So again, even though this does represent a win for Harry, even the judge is acknowledging that it probably was not Harry's phone that was hacked. Funny enough, the reason Harry won this one is because of the reported phrase two-faced shit to describe Mr. Buell. Apparently that was taken directly from a voicemail, but MGN did claim the information came from a confidential source who specialized in royal matters. Well, it sounds to me like the judge made the right decision on this one. It sounds like William's phone was probably hacked, and that's how they got that little gem of two-faced shit. And that concludes part 1 of this little video series examining Harry's claims against MGN. I do hope that you'll tune in later for part 2. Now before you go, please don't forget to like and share this video with anybody else who would enjoy it. And don't be afraid to click the subscribe button to get more updates in the future. Thank you so much for tuning in, have a lovely weekend, and we'll be back to see you all tomorrow.